Good afternoon. Welcome to Employer Exchange by Monarch Law. Our goal is to help small business owners improve their workplaces by sharing personal stories and discussing relevant legal issues. Most episodes, you'll hear from a local business owner with an employment story to share, and sometimes there may be some horror stories. Today, I'm joined by Dan Seiden, my partner at Monarch Law. Dan, how's it going?
Good, Tony. How are you?
Doing well. Busy Friday. How about you?
Yeah, absolutely. An array of things as always, and staying busy for sure.
I'd like to go over some of our background. We didn't really get into much of that last time. So why don't you tell folks kind of your law school and work history after law school?
Yeah, definitely. Fighting the sun a little bit here, so sorry about some of the oddities with the camera. But so I went to Quinnipiac Law School. After graduating, I went to Fordham for undergrad. After graduating Fordham, I worked for 2 years in a couple different jobs. One actually was real estate centric, where it was real estate development, and then went to Quinnipiac with the idea that I was going to do transactional environmental law. And it's funny where life takes you, because that's not necessarily what I do at all. So graduated Quinnipiac in 2008. I personally loved law school. I enjoyed the people that I met. I enjoyed the classes that I took. And after hearing so many horror stories before going to law school, I feel like I'm one of the fortunate people. And that was a great experience for me. So graduated law school in 2008. So we were in the middle of a financial crisis at that point. There weren't many jobs out there. And I was fortunate enough at that point to find a job actually in the New Haven Superior Court as a clerk. It was a job I never knew I wanted, never thought that I wanted. It was offered to me. I talked to a few people who were actually practicing at that point, and they thought it'd be a great opportunity. And in hindsight, it 1000% was. So I clerked for a couple of years, and then from that job got my first opportunity to go into private practice. And that was about the same time that you and I had met. It was a mid-sized firm, I'd say, small to mid-sized firm, and was there for 10 years and got to practice in a wide variety of different areas of law, from personal injury to real estate to I took on some of my first employment cases at that point. As things progressed, aspirations, etc., our relationship progressed. And over time, as you know, here we are, we were able to kind of put our forces together, and Monarch Law became a thing of 2020, when we were both ready to take the next step and build a practice. It's been a great ride. And now at Monarch, I'm able to focus and hone in on some more of the areas that I want to do, and kind of weed out some of the things that I don't want to do with the work that we do here. The employment law, which is a huge focus, to the real estate law that I continue to do, and the personal injuries. Just lots of opportunities, lots of work, and staying busy.
In terms of your employment cases, like what would you say the split is, employee versus employer representation?
Employee side, it's got to be 90%. I do take on employers. I think being in a position now where we are managers of a law firm, employers may look at us a little bit differently, but right now it's definitely 90-10 for me, employee heavy.
I'm probably 60-40, 60 on the employee, 40 on the employer side. Dan's a little bit more heavier on the employee individual side. But the employer work is the handbooks, the internal company policies, the employment contracts, severance agreements, things like that, as well as consultations, talking about employment practices. We also do those employment practices audits, and then litigation defense. When we can get those, we enjoy using our knowledge to our employer clients' benefit. I went to Western New England in Springfield. At the time, it was Western New England College, and I was a night student. So I went part-time at night. I worked full-time in the day. I worked at a law firm in Hartford. I was in the mailroom, so I was the guy pushing the cart around, handing out the mail, sending the faxes.
What do you think of that? How did you like that side of things?
I loved it because it was low stress. I got to meet a lot of really good lawyers and see how a huge firm operates. The name of the firm was Bingham McCutcheon. And they had 3 floors in the Hartford Steam Boiler building. Those associates would give me their study notes, tape cassettes that they had. I would listen to them on the car ride up to Springfield from Hartford. I worked at a place called the Trumbull Group, where they did bankruptcy administration. I did that full time for about a year. It was really interesting. And then from there, did a law clerk position at a small firm in Springfield, Burstein Law Offices. And out of law school, he actually was in the Hartford Superior Court and became a temporary assistant clerk there for about 6 months or so. Met someone whose husband's firm was hiring. She was an attorney at another firm. She put in a good word for me, got the job in Waterbury, worked at that small firm for 2 years, did insurance defense in Cheshire for 2 years, and then started my own solo practice in 2011. Was on my own until about 2020. And then when we joined up, and I think even before the school stuff too, we've both had a lot of experience working at places. In the first episode, we talked about, your experience during COVID at a law firm, my experience way back when I was at a movie theater and the supervisor was taking my super combo bonuses.
Yeah. I mean, you and I both come from kind of the blue collar background of work. We both came up grinding, I think. That was one of the things that kind of always drew us together. We always shared that. And I mean, I've had, an array of jobs from property maintenance to real estate development to I was a sandwich artiste working for Subway. I was a barback. That's what I did as kind of my night job through law school. And then my day job through law school, when time permitted, I worked on the back of commercial fishing boats.
Yep.
And it's just a different perspective than sitting in an office. And those jobs definitely come with their own ups and downs and everything. The real estate development job was interesting because that was actually part of a bigger office. I was a kind of a hired hand to help get that project off the ground. It was right out of college. And I was working with other younger people, but I was also working at the same time with people who had been in their careers for 20, 30 years. And it was interesting from my perspective to see how some people acted and reacted and went to their job day in and day out. And I mean, I remember 2 martini lunches and watching some of these older employees going and not having a second thought about it. And I'm straight out of college thinking, man, this seems like something that should get you fired. It, didn't happen. I don't know that anyone was, none the wiser at the stage, but as somebody new to the workforce, new to the professional workforce like that, and to see that taking place was certainly eye-opening. And these are people that would try to give me advice about how I should pursue my career. And it's you got to take it and kind of look at it. And looking back at that now, I mean, there were so many things that came out of that. I'm sure you've kind of seen some of that stuff in the different positions you've been in.
Let me ask you about the martini lunch or whatever that was. Anything ever come out of that?
I mean, I didn't work in the same department, thankfully, so I didn't see it firsthand, but I know that there were rumblings. I think that ultimately, I can't say for sure that it's what ultimately led to separations of employment. But my guess is that lack of performance over time and kind of I think having an approach to where you think that you can do that and then go back to work and not have ramifications from it with people who are partaking in that.
Yeah. Talking about grinding, I was just talking to my son about this, but I think I could have been about 11 or 12, started a paper route, New York Daily News. I lived in Brooklyn, and a buddy of mine, there was a distributor right across the street from where I lived. And we had a huge route. It was enormous. And it was so big that his dad at one point was driving us around in the winter when we couldn't ride our bikes because of the snow. And we were just chucking. I mean, we were literally chucking newspapers at houses, hitting like the metal, the doors. Papers would be found in the bushes. But generally, we did a really good job. And we went around collecting Thursdays and Fridays. And, middle school kids, we had a lot of money, relatively speaking. I'm pretty sure we didn't get paid a wage. I think it was all just whatever we collected. And then we got to keep a percentage. And, looking back at it now, I'm wondering, was I making minimum wage at the time? Was I misclassified? That's, an issue that we see a lot in our practice now when clients, or even employers, but also employee clients call us. So yeah, that was something that kind of just stood out to me.
It's a great question. I remember I would fill in for my buddy when he'd go on vacation with his paper out, and
Yeah.
we were promised whatever tips people gave us. That was my earnings back then. Um, and yeah, the question of wages and who gets paid what, and are you a tipped out employee? Are you entitled to this? Are you entitled to that? Talking to people who are in the restaurant business now, it's definitely a question, and I think it's going to become more of a question as things change in the state of Connecticut as well with minimum wage and how you have to treat tipped employees. I think we're going to get more calls on that. It's the trying to guide people through this stuff. Nothing that we do in the employment law turns out to be black and white. I feel, we're always kind of treading in this area of gray.
Yeah.
How do you approach that? I always, you try to talk to people and you tell them, listen, I wish I had a better answer for you, but sometimes we're in a gray area. What do you think?
That does happen a lot. I give, just like you, right? We'll give our best answer and let the person know either it is a gray area. Like we've researched this, we've researched it recently, and there's still a question, or maybe it's a new law and we haven't seen it, come into action and with case decisions. Or as we'll say, look, it's been a little while since we've researched that issue. We'll research and get back to you. One of the things that came to mind as you said that is, the whole movement behind tipping and the ease of tipping with these tablets, cashiers. And it's like you order a coffee and they turn the tablet around and it's already preloaded to 20% tip. And it makes the person feel, oh, I'm just going to sign this. I don't want to look like a jerk and click off of it or click no.
Even if it's not preloaded, you feel obligated to do it.
And then whose tip is that? Is that the cashier's tip? Is it the tip of the business? And we won't get into that now. Why don't we move into kind of us being an employer for the next 5 minutes or so? There's no legal obligation for any employer to have a handbook, but we do our best to try to keep that updated and keep it short as possible. What has been your experience as a business owner now with internal written policies and handbooks, things of that nature?
It's one of those things that I think when it's there, and this is kind of from conversations that I've had with our own employees, like I think that they like to have that as a fallback, as something that when there is a question, let me go back and take a look at it. Like, okay, what are our holidays? I mean, that's probably one of the most prominent ones that we have, or what's our PTO policy? And while we don't have to have anything written, I think it's a bonus to the staff, and I think it ends up being a bonus to us because we've now set out something clear to them. I find that it's appreciated more than it's not.
Yeah, I agree. As an employer, you don't really want your employees wasting time going to management or supervisors, and continuing to ask if that's somewhere. And one of the really important policies would be the complaint procedures.
Yeah.
How about internal complaint procedures? Have you seen that come up a lot?
In our first podcast, I talked about being fortunate not having to do that in my own life. It's one of the first questions that you're going to ask an employer. What's your policy? What's your procedure here? And a lot of times with small businesses, we don't have one. Okay, well then how are you going to effectuate that uniformly among your employees? When you have a complaint, what do you do? How do you field it? Who's your go-to person? And you start asking these questions, and inevitably it's, oh, I need to work on this. Can you help me? And obviously we want to. That's what we would like to do to get people on the right path. But that's what I'm finding when I'm getting these types of calls from the employers that are reaching out to us. Who like you do a lot more of the employer side so far. Have you had an employer where you're just like, how are you in business right now?
The smaller employers, sometimes they do have a handbook, but it's a 70-page handbook that their payroll company drafted, and it's generic. And
they don't even know what's in there either.
They don't. Or it lists people, right, who to complain to, and there's no one even at the company who has that title. And so if the employee actually read through all those pages and got to that procedure, they're like, who is the general manager here? I don't know. Or there may not be a mechanism for like a second person to complain to, and the person
Now,
says, I just didn't feel comfortable because you're the one who's going to be reviewing my complaint, but you're also the harasser.
yeah, I mean, I think that's setting up the employees for failure. I think that's setting the employer up for failure in that situation. What do you think when there is this generic handbook? Do you think an employer is exposed in that situation?
To some degree, yeah, I do. Because if it's generic, I know for the ones we draft and what we have for our employees, we make reference to, there are federal laws that we make reference to, Federal Family and Medical Leave Act, but there's also Connecticut, right? There's a new, the last few years, Connecticut paid leave. And so we provide, there's no real legal requirement from that act that says you have to put something about this in your handbook, but we do so people know about it. So just those generic handbooks, if there's maybe the wrong law or the wrong state reference, there could be some exposure. If there is a particular state, that wants something specific, like a notice, and it's not in the handbook and it's nowhere else, then that could lead to some exposure. As we've concluded ourselves doing these and doing them for our own business, it's way better to have something short, to the point, people are going to actually read and not roll their eyes at.
We got to be able to read it ourselves. Like, the employer has to know it's in there.
Yeah.
And that's the thing with some of these generic ones that I'm finding. And I think that when you have something that's as extensive, or, it's all legal jargon, nobody understands it. And I feel like how can an employer, I feel like what we talk about a lot is, if you have a policy or whatever you do, you got to treat your employees equally, uniformly.
Right.
And if you don't understand what's in your policies, how can an employee understand what's in the policies? And then how can you effectuate that across the board? And it's a tripping point, I think, for it could be a tripping point for us. I mean, I'm happy that we're on top of it, but it's definitely a tripping point for the people we talk to.
And what about severance? Is there a severance policy? If there's a generic handbook, is there something in there or not in there, but the owner pays severance selectively? There's exposure, right? There is a policy and we're supposed to get 1 week for every year that we've worked here. It's in your handbook, but he's giving out 2 weeks for every year, but selectively. That could be lead to some kind of discrimination claim, or, something else. Let's wrap it up in the last minute or two. Any other practice areas that you handle, and if there's ever any overlap?
Yeah, I mean, with the real estate, it's transactional for the most part. So I'm doing purchases and sales. We do residential, but I also do a good bit of commercial. So the commercial side brings in employers. And so I've had transactions where I've helped somebody just review a lease, and all of a sudden, hey, can you help me with this employment side as well? So setting that up and talking to people about, sometimes in a lease, ADA requirements, which is property conform, does it not, does it have to? And then, I get to meet and talk to employers, businesses that way. So it's been a great opportunity. And, on the personal injury side of things, you're looking at premises liability. If you're representing either a homeowner or an investor who has multiple properties, what can they do to protect themselves for premises liability? And they're not necessarily an employer that in that sense, but whenever you are an employer and you own property, premises liability is definitely out there. As there's a reason there's billboards up and down 95 and 91. I like what we do. We're not at that level of PI work, but I wish that I had the passion for workers' comp that some other people do. But what's your take on that?
I don't do a whole lot of workers' comp. I typically will take a case where there is some employment aspect to it, right? The person has a workplace injury and led to a disability. Now, maybe there's a failure to accommodate or a disability discrimination claim, or, maybe there's something else like FMLA, that the person's rights under the family and medical leave laws were violated. And then personal injury, like you were saying, yeah, if there's a disability because of this big, bad accident, and it impacts that person at work, and then FMLA might come into play, paid leave, etc. And, for the employers, they have to be really careful, because they're put in a really bad predicament where they have to run a business and they have to keep the lights on and everyone's got to work and pick up the slack. And, the calls we get are, how long am I supposed to keep this guy? And my first question is always, did you offer FMLA yet? Did you offer them unpaid job protected leave?
And we could sit and talk all day.
Thank you everyone out there for listening. Hopefully you enjoyed this podcast. If you do, please spread the word, and we'll be coming back to you soon with more episodes, with interviews from local business owners and the New Haven and Hartford County areas, talking about issues that they've had with employees, scenarios that we could talk through, talk about the law, and hopefully build better workplaces. So until next time, everyone, we'll give the old tip of the cap, Dan, and we will see you soon. Thanks.